The federal resources super profits tax is only going to end in tears, Mr. Rudd. It'll either mean you'll have to backflip, or alternatively, you'll lose the election. And if you do win the election and you try to bring it in, it will end in a morass of legal and constitutional litigation which will end in disaster. There's nowhere to go with this tax but to withdraw it. The very way in which it was introduced, presenting it to a lock-up, a media lock-up, presenting it as a fait accompli, was contemptuous of the Parliament where it ought to have been released. It misused the public service. The head of the Treasury has been conscripted into being a political spear carrier for the tax, and that certainly undermines the independence of the public service. But the problem is that once this tax is introduced, there will be difficulties. The fact that it was done this way, the fact that it was done without consultation, reflects very poorly on the so-called kitchen cabinet, the politburo-like group which runs the federal government. If they had allowed it to be discussed, they would have seen the weaknesses in it. And the weaknesses are certainly serious. Apart from the economic questions and the way in which the tax affected foreign investment, there's no doubt about that when you look at what's happened to Canadian shares and what's happened to Australian mining shares, which have gone in completely different directions. The government is saying that what it wants to do is to protect the minerals which belong to all Australians. Now, this is not just so. The minerals are vested, as we say, in the Crown, but not in the Crown in the right of the Commonwealth, not the federal government. It's the Crown in the right of the states. And it was that way before the federal constitution was developed, and the federal constitution was enacted and adopted on that basis. The minerals stay with the states. That is absolutely clear. And to make it very clear, Section 114 of the Constitution says that the federal government will not tax the property of the states. And the minerals are clearly the property of the states. No doubt, any legislation will try to get around that. But I would expect that the High Court would look through any such devices. But there's another problem, and the other problem is this, that this looks very much like a nationalisation. In fact, the so-called Brown tax on which it is based involves the Commonwealth effectively buying a 40% share, or if it wants it to be 40%, and then getting 40% of the profits. And this is one of the criticisms of this tax, that the Commonwealth takes 40%, but it doesn't give back anything until the end. And then it agrees to cover losses. Now, had the Politburo revealed this, discussed this with Parliament and the people, the very common sense fact would have emerged that the public just will not stand for the Commonwealth drawing a cheque for, say, billions of dollars to pay to a foreign investor, perhaps a foreign government corporation, for the sorts of losses, for example, that BP has run into in the Gulf. The government would have to enact legislation to renege on that promise. Now, the constitutional fact is that the federal government can only nationalise assets on two conditions. Firstly, it has to be for the purpose of the Commonwealth. How can minerals owned by Queensland or Western Australia, how can taking them be for the purpose of the Commonwealth? And there's a second condition. That is, that the Commonwealth, the federal government, pay for this on just terms. Fair compensation. The Commonwealth isn't paying anything. I would think that the Commonwealth would have very serious problems in the High Court. And of course, the miners are going to challenge the legislation, and the state governments are going to challenge the legislation. This proposed tax undermines the federation. The states have already had an enormous proportion of their income taken away from them. We are financially the most centralised of federations in the world. The states get less than 20% of their income from their own resources. They spend 40% of the public money of the country. The founding fathers of the United States knew that this would be a recipe for problems. They knew, as anybody with common sense knows, that just as a healthy adult who is welfare dependent becomes dysfunctional, so a state government that doesn't rely on its people for its own income, and in explaining to its people how it spent its money, will also not perform at the best level. Mr. Rudd has already tried to take 30% of the GST which Mr. Howard risked the 1998 election on, so that he could enact it and then give it to the states. The GST, which Mr. Rudd vigorously condemned when he was a backbencher in the federal government, in the federal parliament. Now, to overcome these constitutional issues, what Mr. Rudd should do is to put a referendum to the Australian people and ask them, is this what you want? Do you want the federal government to take over even more income? Do you want the federal government to take the minerals, effectively, from Queensland, Western Australia, South Australia, Victoria, New South Wales and Tasmania? That's the way to do it democratically. But Mr. Rudd would also have to take away the retrospective aspect of the tax. You see, the tax is now going to apply to those projects. There's only a limited number of projects which emerge from the exploration, the heavy costs of mining and so on. This is a very risky investment. There's only a limited number that emerge as profitable after you've paid out everything. And these are going to be taxed at 40% above the, apparently, the long-term bond rate, 6%. Now, the fact is, this will cause Mr. Rudd enormous problems, enormous legal problems from which he will be unable to escape. Australia is a party to a considerable number of foreign investment treaties, treaties guaranteeing foreign investment. And it's very clear that this expropriation would be a breach of our duty in relation to foreign investors, that they would be entitled to demand either compensation or restitution, and that the remedy, the compensation for example, be prompt, adequate and effective. That's the standard of international law. So Australia, if the tax goes ahead and applies to existing projects, Australia will be hauled before international arbitral tribunals appointed from a World Bank agency in Washington, and it is likely that orders for substantial compensation or restitution be awarded by those tribunals. There'll probably be one or two test cases, and the others would be ready to flow. Well, you could imagine what 40% of the value of all the mines in Australia would be. You can't imagine how Australians could possibly pay the compensation that we'll be up for. And there will be Australians of the present generation and of the future generation who will have to do that. Mr. Rudd, it's time to withdraw this tax.